Most of you know me. I'm I'm the Southwest Florida marketing representative for Tower Hill Insurance. So I wanted to just take a quick minute to recognize two other people from Tower Hill. Actually, three. Where's the four? Stand up, please. So we have Kathleen Craig, VP of Marketing. We have Erica Young, who is our agency claims experience liaison. Some of you probably have talked to her before, so it's good to put a face with a name. And then you can introduce yourself.
Chris Rigola.
Thank you.
Nice to meet you.
And Blake. Blake Simon, who will be part of our panel today.
Thank you. And I'm Marlene Rome, and I'm with the Damex Corporation. And with me today, I have Ryan Yummel, who does our marketing down in our Lee County and Collier County areas, and also estimating, and Robert, who is part of our panel. So again, I want to thank the expert panelists for being here and giving their time and effort in doing this for us. I do regret to say that Mr. Jaworski had a family emergency yesterday, so he was actually on his way down here from Tallahassee when he had to detour to a family member. So, but I am very happy that he can join us through telephone. So, Mr. Jaworski, are you in? Oh, hello.
I am. Can you hear me okay?
Yes, yes. So I'll go ahead and I'll introduce Mr. Jaworski. He was appointed as Chief of Staff of Insurance Commissioner David Altmeyer. Before that, he served as legal counsel for the Georgia Office of Insurance and Safety Fire Commissioner, where he was responsible for advising the commissioner and senior staff on policy decisions and performing administrative, regulatory, and litigation duties associated with the legal unit. Doctor degree from Samford University's Cumberland School of Law. He has been a member of the Georgia Bar since 2014. So the mission or vision statement of the Office of Insurance Regulation is that OIR's consumer-oriented regulatory approach helps to promote the availability of reliable and affordable insurance products in a stable, robust, and competitive insurance market. So, and then our next panelist I'd like to introduce is Blaise Simon. He'll go after Mr. Jaworski, and Blaise is from Tower Hill Insurance Group. Mr. Simon is a field team lead and has approximately 10 years of claims experience. And he has served Tower Hill Insurance Group as a field adjuster, catastrophe site manager, and is currently the field team lead. Tower Hill's mission statement is to provide unsurpassed insurance products and services that enable their customers to protect their homes, businesses, and property. And our last panelist, I want to introduce Robert Yoho from the Damex Corporation. Mr. Yoho is the Vice President and one of the estimators for the Damex Corporation, has been with the company for 21 years, and is a certified and licensed holder for general contracting and mold remediation. The Damex Corporation's mission statement is that they are a team of skilled individuals committed to excellence in customer service and craftsmanship who strive to improve the quality of the disaster restoration industry one customer at a time. So from this point on, I'll turn over the floor to Dion.
Thank you. So our program today will start with questions from each of the panelists. Once they have answered the questions, we'll take some time to answer some of your questions. We had planned on doing that at the very end, but what we're going to do is let Mr. Jaworski answer your questions so that we can go ahead and hang up and let him go to his emergency. So what I'm going to do is I'm going to go ahead and start the program, and I'm going to ask him to define assignment of benefits and how does it work.
Thank you very much. I appreciate the opportunity to speak to all of you. Not only because I enjoy talking about these topics, but because I'm a proud alumnus of Lemonade Bay High School.
Yeah!
And I just enjoy getting down there as much as possible. I'm sorry I didn't be there in person. But assignment of benefits is a situation that occurs fairly commonly in our market these days. And I want to emphasize that we have the Office of Insurance Regulation has never been opposed to the concept of assignment of benefits itself. It can be a good mechanism for individuals who are sometimes in the worst moment of their lives after some sort of loss has occurred to their home, to find a quick remedy and get a restoration specialist or other specialist, whether it's roofing or otherwise, on the ground and begin making repairs. And what it is effectively is the ability for a consumer to assign the rights to a policy contract, the benefits, not the rights, the benefits of a policy contract to a vendor in the hopes that that will expedite a claim and take the burden off of the policyholder. In which case, ultimately, the vendor would then receive the payment directly from the insurance company, and leaving the consumer to focus more primarily on repairing, putting their life back together after they suffer loss. And so what we've watched over the years is this practice has grown and grown, and so we started watching it very closely beginning in about 2013.
Thank you very much. The next question would be, what is SB 122? When will it take effect? And please explain briefly the provisions included in the bill.
Absolutely. So SB 122, it was sponsored by a number of members in the Senate, including the chair of the Insurance Debate on the Senate side. And ultimately, it passed the legislature this past session, and it's awaiting signature by the governor. And there's no indication that he would not sign the legislation at this time. Effectively, it was designed to protect all the interests involved, starting at the consumer level, the insured level, all the way up through to the assignee, the assigner, and the insurance company, and in an overall effort to protect the rights to assign a contract, but also ensure that the assignment is not abused. And so some specifics of that, of the language for those of you folks that may get questions from policies that you service, the legislation gives the insured 14 days to rescind the assignment. It gives the insured 30 days to rescind the assignment if the assignee has not begun substantial work during that 30 days. It requires the assignee to provide a copy of the AOB to the insurance company within 3 days. It limits the assignment of benefit to $3,000 or 1% of coverage A during emergency situations. And it prohibits assignees from charging mortgage in a way that disincentivized abuse by whether it be unscrupulous vendors or attorneys that were abusing that one-way attorney statute. And we think that this does probably disincentivize that behavior. Finally, for those of you guys interested, it does put some specific requirements on Citizens Property Insurance Corporation as it relates to the fact that they are not able to implement any additional rate increases until they've shown to the Office of Insurance Regulation projected savings from this legislation.
Okay, thank you. The bill addresses property insurance, but does not include any provisions of limiting AOB for auto glass companies. Are there any plans in the future to reform legislation to include auto glass companies?
So I would be very surprised if the issue was, if there weren't individuals in the legislature next session who didn't take up the auto glass portion that was originally in Senate Bill 122 and originally in 7065 on the House side, but got stripped towards the end of the session. I think that auto glass is an issue within Florida's auto market. It is something that we watch very closely. It's responsible for a huge amount of the overall AOB litigation that we see in the state. We do keep in mind, however, that when we're looking at the two markets, auto versus property, we have pretty clear and direct evidence of the way that property AOB was, or that AOB abuse was affecting the property insurance market. And the auto insurance market, that market, while rates are increasing, it's a fairly robust and competitive market. Nonetheless, there is clear evidence that there is abuse that's occurring there, and I expect that there will be some sort of legislation proposed to try and address that.
Thank you. What are the factors motivating contractors to use and abuse AOBs? What is one-way attorney fees? How will the provision in the new law regarding one-way attorney fees statutes be implemented? And do you see the AOB attorneys challenging the new law?
I definitely think there will be challenges to this new law. I think they'll probably be fairly swift. We've already seen a couple of pieces from attorneys or consultants that kind of had an impression in our marketplace where it's causing rates to go up. I think 93% of the rates that we have had filed in the admitted market in the past 2 years have been for increases. And that was not the case between about 2011 and 2016. It was a far lower number. So I think that we kind of reached a point when we look back at the water loss trends and look back at the frequency severity of water losses, we see this cost point rising, and we see rates going along with it to the point where it's harming the ability to obtain insurance in Florida.
Thank you. We've kind of answered some of those questions, but the next question is, what are the effects of AOBs to insurance rates, if any, to repopulating citizens and to other domestic carriers?
So yeah, absolutely. So when we look at as I mentioned earlier, we think it's obviously historically, hopefully this legislation that just passed will help address that, but it is impacting rates. We firmly do recognize that fact. We think that if this has not been addressed, and we're hopeful this legislation will address it, we think that various areas of Florida would become less and less desirable by insurers to cover going forward, especially in the Tri-County area down in South Florida where AOB abuse is most prevalent, but also in other markets where we started seeing it in Central Florida and Tampa and North Florida following Hurricane Michael. So we think that would ultimately lead to insurers, and we saw a little bit here and there with some insurers pulling out of the Tri-County area where they had said, you know, we can't sustain these losses, so we're pulling out, which leaves fewer choices, and ultimately we think consumers still need to be insured, which leads them back to the insurer of last resort, which is Florida citizens. And, you know, we've had the EPOP of citizens from 1.2 million down now to about 400,000 thanks to the EPOP program. And the fear was and is that AOB abuse would lead to a repopulation of that citizens.
Thank you. With the new law, how do you see this affecting citizens in other domestic markets? And again, I think we've answered a lot of those questions.
You know, our hope is, again, that it will, number one, stabilize rates, if not lower rates. And rates, I mean, as everyone's probably heard, rates it's complicated to just say, if you pull lever A, then rates will either go up or go down. It's really hard when it all is said and done. Rates have all these threads of costs and profits and other things that affect it. And so it's hard to say if you just pull lever A, fix AOB, the rates will go down or the citizens won't be repopulated. But, you know, it is a factor, and we're hopeful that it will ultimately will lead to a decrease in rates. Overall, at least it's stabilizing the market where we don't have some of our domestics being shy of writing in certain areas because of this particular problem.
We have one last question. With the new law, will there still be AOBs allowed for property insurance? If so, what should a homeowner look for to determine if they're signing a contract with an AOB?
I think it's a great question, and I think it's one that, you know, any agent or anyone that's consulting with the property owner should really, you know, and we try to message this to the CFO Patronus has been all over trying to message about what you get and what you get about when you sign an AOB. It can be a great tool to argue, but you know, when I was touring the Panhandle recently with some other folks, one of the things we heard is that, you know, insurers would come up to us and say, you know, I signed this document and I haven't heard from my contractor in 4 months now, and I don't know where they are. And the problem, one of the issues you have with an AOB is you really, with the exception of the new law in 765 and Senate Bill 122, the rescission period varied and was difficult to enforce, and you know, after a certain amount of time, you're just stuck with it, and you're at the whim of the contractor to come in and repair the problem. So we think education, like I said, AOB can be a great tool, but we think that anytime we're talking to consumers about whether or not they should or should not assign their benefits, we encourage people to look very carefully at everything they're signing and their current policy. And we always encourage consumers, you know, the first call that they should make is their insurance company, because they need to be aware of what they're encountering, and they can often provide help and information and get folks in a right place where they can get the help that they need. But anytime, and we also encourage if anyone is ever uncomfortable or what being asked to sign by a vendor or their insurance company or anybody following a loss, that, you know, we have resources here in Tallahassee to call the CFO's Consumer Helpline and get information answered quickly so that they can find the help they need. You know, but we always encourage people, you can sign an AOB. It may be a good thing to do. It really depends on your individual circumstances, but you should read everything carefully before you sign them and seek help either from your agent or from the insurance company or from the CFO's hotline or anyone else that is knowledgeable in this area.
Well, thank you, Mr. Yarowski, for your time. We truly appreciate it. At this time, we are going to go ahead and open it up for any questions before we can go ahead and hang up from the call. So, Marlene will walk around with the phone and ask something.
For instance, is I have a client that is not at any work done to her home for about a year. And she does not obviously want to use that contract anymore. We saw there was a right of assumption for 30 days without considered work being done. So she now, she signed it before the law was in effect. And the law doesn't affect if she's able to use that to get out of her AOB contract.
No, and unfortunately, she won't. In fact, there's a provision that was added to the law for the later stages that specifically includes the ability to retroactively apply provisions. I would love to talk to you about her situation if I could get your contact information later.
Yeah, I'll get it.
That can be helpful.
Thank you.
Any other questions? I do have a question. Can you explain a little bit more of what exactly the one-way attorney fees and how will, with the new provision, when does the insurer get paid and when does it get paid to the plaintiff's attorney?
Absolutely. So the easiest way to explain it is that when you had under the one-way attorney fee statute, and again, this was designed originally kind of as part of that bundle that came about when we were talking to kind of incentivize insurers to do the right thing. I think was kind of the notion behind the legislation when it originally passed. And the one-way attorney fee statute, as it was originally drafted and then interpreted by the court to be applied to assigning the benefits, is that if you have a claim and you have a pre-settlement judgment or a pre-settlement offer that claims, you would, and then if that offer was refused, if there's an ultimate offer, if there's an ultimate judgment, and that judgment was for $1 more than that pre-settlement offer, then you would owe all attorney fees to the attorney for the opposing side, all the legal fees associated with it, and that would ultimately could cost thousands of dollars. And you see that in auto glass is kind of the best way to see the differential. You'd have a $50 auto claim for auto glass, and it would be expanded ultimately to $2,000, $3,000, $4,000, sometimes $10,000 when all the legal fees are done, and they were done roughly back and forth with it. Under this new law, what you have is a new framework where you have a sliding scale for attorney fees, and you have as far as what the percentage basis is for each side of. So if you end up with less than 50%, say, then you wind up with one side getting it either way, and then there's 75 and 75. This was a very getting this sliding scale is probably one of the more controversial portions of the legislation that came forward, and it ultimately got a little more complicated than it probably would have been optimal. But I do think it has the effect of making all parties involved in any kind of litigation assess whether or not they should proceed with litigation, because ultimately it comes down to whether or not you're more likely to win and who is on the hook. Whereas before, under the original only attorney fee statute that applied, it was skewed heavily in favor of the attorney, if that makes sense.
Well, I guess I'll let you answer the question, even though it's supposed to be.
So number one, we really don't have a plan as of yet, since this is all just transpired. That's number one. We had already implemented, and the department made us take out wording that forced an AOB to get 3 signatures. Well, all the signatures of all the parties. So husband, wife, and the mortgage company. The OR made us take that out a year and a half or so ago. What's interesting is ASI still uses that language today because they have a court case. That one court said no, one court said yes, and now it's the Supreme Court to break the tie. So they've still been allowed to use it, even though we had to take it out of our wording. I would presume we're going to go down that path again and make sure that all those signatures are required. So that's the basis of what we're going to be looking to do. We have not talked to our actuarial department about it in detail, but that's the 50,000 view.
Thank you very much. Yes, it does. Okay. So, ladies, what should a homeowner do first if they suffer damages to their property?
So that's big picture what we're going to be trying to do so that we can, again, try to circumvent through you all if your client signs it and does not know what they did.
Yes, sir.
Will any of the people in Castle Care, the companies in Castle Care, look for an AOB?
Oh, no, they're not going to ask.
So anybody in Castle Care is not going to ask the insurer to sign an AOB?
That's part of the requirement to be a part of Castle Care. You're not allowed to request an AOB or have AOB contract.
So that eliminates a lot of that.
Yeah, that's, and then I want to say, hey, don't sign an AOB, they'll call Castle Care, and then they show up and, like, oh, they're signing here. So that's good.
Whether they sign that AOB or not, we're not under no obligation to provide insurance documents to these guys, right? This new legislation. We're not required as agents to, since they're assigning their benefits, it's a third party, but like at least in my agency, if they request insurance declaration pages, we don't give them anything.
No, I would direct that straight to the carrier.
Yeah.
I wouldn't do anything.
Yeah, that's what we, and then the second, we keep talking about water. When is this roofing thing going to stop? When is that going to stop? You know, the whole roofing problem that we're having, at least in my neck of the woods, with these guys showing up with ladders and, you know, going to come in your house. And I mean, do you see AOBs with at least in the Southwest Florida, are you seeing a lot of them with roof losses?
So
They're coming in with quoting the statute. I mean, in my neighborhood alone, I'm telling you, it's all, this company went in there with the truck and the guy, and all of a sudden, my neighbors are all getting.
100%. They go door to door, and I've never seen so many $100,000 roofs in my life.
Yeah,
It's
so
amazing.
what are you doing? Is there anything going on with that? I mean, statute's gonna end soon, right? 2 years is it? 3? 3? Shit.
yeah. So it is, I mean, we're pushing, I mean, just in my, up in Pasco County where I live, we have, I work from home, and yeah, I've gotten two roofers knocking on my door, asking me, hey, I think you might have hail damage. It's like, no, I don't. But it happens. But just the best thing is, as the claims comes in, we're gonna be handling them. We'll fully expect it.
And Alan, to your point, we are getting more Irma claims than even Michael claims to this day.
That's what I'm saying, yeah.
And
Like,
and
really?
Erica can speak to this as well, but a lot of times when we get a late reported Irma roof claim, we just send an engineer. Because then the engineer that will stand in court as our expert that review the risk versus a field adjuster. They have the credentials, and that's a lot of what we're doing now.
And they're an independent company, so we can honestly stand by and say, this is an independent third party that's stating this. It's not Tower Hill,
Tower Hill
but we
claim.
are standing by the independent third party's assessment of the roof.
Oh, real quick, the documents.
So unfortunately, from my time in claims, I know that if a AOB holder requests documentation, legally we have to provide it to them because they are considered a policy holder at that point. So if they request a copy of the policy, deck page, whatever, we do have to provide it. Now, we won't offer it in any way, shape, or form, but if it is requested, we have to provide it.
You do, we don't.
Correct.
You don't, yeah, I do, you don't.
Well, if they hire an attorney, you're gonna get it anyway, because they're gonna request it right away.
Yes.
So,
Okay, I guess we'll say, is there any other questions before we move on?
Do you guys still use Xactimate? Is that the industry software that you guys use in claims for your adjusters?
We're primarily using a program called Stability. So it's I would say it's comparable to Exact.
So the next question is, what if the water mitigation contractor says that they only use AOBs for some carriers because it's necessary?
I mean, yeah, that's a tough question, but I would just. If it's necessary, I would direct them to our vendor coordinator. I can speak on behalf of Tower Hill. I would direct them to our vendor coordinator to explain why they need the AOB. But also, if they want to be a part of a preferred contractor program, with Castle Care or Alacrity, it's kind of the parent company of Castle Care. It's to get vetted and we can start using them. But I mean, prefer not to get into the AOB field.
Okay. What should an agent do if a water mitigation company approaches an agent and promises not to do an AOB of any on their referrals, but then they still use an AOB to other agents?
I mean, I think I answered that question in my last answer. So just direct them to Tower Hill and we can talk to them, about that process. So really push them towards our, Castle Care and have them get set up and get vetted through that program. And if they want, to work on Castle Care claims, or Tower Hill claims, that's the way to do it, is through Castle Care.
Yes.
Yeah, I like the department's website, because it's a good way to go in there, and they have a section on AOB, copy and paste that link, and that's really nice to send it to your client via email. So read this before you sign it. So that's a nice third party to kind of push your customer into not signing.
Yeah. Go ahead.
No, I also brought AOB brochures that's on your table right now. Those are from the OIR, so I have a stock of them. If you want them to give them to your insurers, please grab some, because I have plenty of them.
Any other questions for Blaze? No?
Yes, sir.
I would just make a comment, if they're gonna use AOB for one and not the other or whatever, then just don't use them as a contractor. I mean, like, why, right? I mean, why do they need it if for that client or for that? And then if there's carriers, I mean, I will say on the other side of the aisle, we do have some rough carriers, and maybe we didn't write directly with them, but they were like Citizens Depot stuff, and we have, you know, clients that are with these policies, and they're just terrible. They're awful to deal with. I mean, you guys obviously provide exceptional service on the claim side, but there are carriers that it's tough to get stuff done with, and so I can see the other side of it when we need to, you know, have a contractor with some teeth on it. I can see it. I mean, I can see why. I don't like it, but I can see why. So there's some comments on this question.
Anything further? Then I would like to thank you, ladies, for your time today. And absolutely.
He wasn't very involved, but Chris Rizzola, he is our field adjuster here in Lee and Collier County. So if you have a Tower Hill claim, chances are he's probably going to be working for you guys. So I just wanted to point him out and make sure, you know, put a name to the face and go hit him up right now. So what happens? So,
It's all roofs. It's all like tile roofs.
Well, I have a quick question.
Yes.
Okay, specifically for the late reported Irma claims, are you finding most are not damaged? Or is there truly some out there? Obviously, it's going to be both, but just your take.
I've noticed our older roofs that are coming up to their age, they're becoming damaged, and we end up buying them because it's so close. The tiles that are missing, if we're missing a couple tiles, we can't match it up, we end up buying the roof. But I've also noticed the areas that I'm in are typically communities, they're elderly, they don't know what's going on, and everybody wants to know why I'm there. And they're like, okay, you know, who are you with, who's your company, what's going to happen with my roof. And they tell me that contractors are coming in with their ladders and they're literally pulling tiles. So when I go up there, I don't know if this is a wind damage or if it's man-made. But a lot of these companies are setting drones up and they'll see cracks. And once I'm up on the roof, it's most likely mechanical, footfall, expansion, ridge caps are expanding, so they're becoming loose, so the contractor says new roof. So now, once they say you need a new roof, if you're older, they start to panic. And everyone says to me, all your clients, they'll say, when you get my age, you're gonna understand, I can't deal with it anymore, I just can't. So they tend to believe the contractor, and they can't handle it. They're like, I just can't do it. I'm there to be forward-facing. I'm gonna help them answer any questions best I can. And if it's broken, I'm gonna fix it. So, you know, if I know for sure that it's wind damage, I'm going to write it as wind damage. But if it's not, that's probably when the engineer comes in. But I can pretty much tell, and I can tell you for sure there's probably 50% of the roofers that are causing their own damage. 25% of them aren't even going up on the roofs at all, so they have no idea. And then there are some legitimate claims, but they're mostly older roofs, or it's because of construction defect. The installers are coming in and they're banging out 100 roofs in a day, and tiles are starting to pop up. Stepping on the tile, they're just all cracking, and it's all because of installation. So, but there are the roofs. Some people do need it. You know, you're 7 years old, you can't get on a roof. I wouldn't. You know, I don't like getting on a roof as it is. But, you know, you don't have the ladder, you don't have the capability, so you don't really know unless somebody goes up there. And how do you do that? Because I can't go on everybody's roof. I'd like to let you know, hey, you don't really need a new roof, or hey, you do. But somebody's got to take a look. So.
The mismatching of tiles, replacing the roof, that triggers ordinance and law coverage, doesn't it?
That's a tough situation. Not in that scenario, but what I'm finding is once a couple tiles go missing, a lot of insureds actually have tiles. I was just in one scenario where a contractor came out, they were missing a couple tiles. I couldn't tell if it was wind damage or he took it. And he already told me, he's like, ITEL's not going to match. So he already sent it out. So I'm thinking, okay, where did you get this tile from? You either took it from the roof or the insured had it. So I asked him, do you have a sample? And the insured happened to be there. He's like, yeah, I got some. And I watched this contractor hit, I thought his head was going to explode. So he had a stack of like 20 tiles inside the garage.
He's all proud.
I was like, here it is. I was like, that's saving these. Yeah. I told him, I was like, just need it for an ITEL. And he was whispering, and he was like, I can't believe you said that. He was so angry with me. So I put in for the repair of the roof. Contractor calls back and says, nope, you know, these tiles are not going to match. And it was 3 different tiles on the roof, 3 different colors, same tile, 3 different colors. It would have matched perfectly, but he wanted the roof and he was upset. So they tell them not to talk to me, but some people just can't help themselves.
So did you body slam him in the driveway?
Even if the
As an
contractor,
estimator of a water mitigation company that doesn't subscribe to AOBs, what is different that you do than the companies that use AOBs?
Okay. I feel it necessary right now to kind of put a disclaimer in here, that every company that's out there that utilizes AOBs is not, it's not a blanket indictment, okay? This is, there's a lot of unscrupulous, a lot of bad players, and this is what we're kind of bringing up. This is what I'm bringing up, at least. But one of the major concerns that we have when there is an AOB company involved is overscoping. Overscoping in our industry is, it just means inflating the claim. It's going in prior to, once you get that call and you're going out to mitigate, you're there before the insurance adjuster is there. So they're taking this and they're running with it. They're going to take out more material than is necessary. They're going to strip the cabinets possibly. They're going to strip the floors. They're going to take things out in their mind because there's a matching issue. But those are not questions that unlicensed. You're not an adjuster at that point. You can't adjust a claim. So these are things that we're dealing with. The other side of it, that inflates the mitigation side. All right. So the other side of it is a lot of these contractors that go out and do the mitigation are also general contractors, such as Damex. And they're signing these AOBs, and without reading them, because 90% or more of people, when they're faced with this problem, are not going to read through this thing line by line. They want you to get the water out of their house. They want you to take care of their fire. They want you to take care of the mold. So that being said, there's a lot of duality in these contracts where you're signing up for not just mitigation, you're signing up for the reconstruction. So that we try to keep as separate as we possibly can. We go in for the mitigation and we offer our services for reconstruction, but we don't automatically assume that we're going to move forward with this. But what that does is now that they've taken out more than they really need, they're going to be putting back more than they need. So it just inflates things pretty severely. Again, that's pretty much the number one concern.
Okay, thank you. Can you define peer review and how can you do a peer review when a contractor with an AOB has already been called out to mitigate?
Okay. As a preferred vendor for a lot of major carriers, we have been vetted. They've gone over our record. We've worked with them in our particular case since 1982. A lot of these carriers. They know our performance. They know what we do. We're not going to go out and take advantage of the situation. The peer review is there, and it's something that's relatively new in the industry. It's there where they call us up when there's a company involved. It's not necessarily an AOB company. It may be any company that they're not familiar with. They'll call us out. We'll go on site. We will scope the loss the way that we would normally scope the loss, using IICRC standards, taking into account the class of the loss, the category of the loss, where the water came from, what needs to be done. And then we put together our scope of repair. We put together, and in turn put together an estimate which can and will go to the insurance carrier. And at that point they have sort of a bargaining chip. They have, we have a piece of paper here that says that we agree with this. Now we can negotiate, and we can, at that point, save the insurance carriers, and we have over the years thousands of dollars by just that point of going into it. And we're also letting me know that we're being paid for this service. So we're not going in thinking that, we're going to do this and we're going to do that. It's a very above board action, and in a lot of instances, when we're sitting on a fence about something as far as can we restore it or do we need to replace it, we're going to opt to replace. Because if I'm sitting in a box someplace in the left of me, they're going to want to know, can you restore that. And if I can't tell them without without a shadow of a doubt I can restore it, to replace it. So we would actually write the estimates a little thicker than we normally would. So there's really, it does help in that matter. Now, going back to what we said before, a lot of times, or sometimes, we'll go into a loss where the AOB contractor hasn't been involved and they've overscoped and they've pulled out quite a bit. All right, but we have to write it that way. We have to go to write for physical damage. We can't really tell why the wire was pulled out, whether it was necessary or unnecessary. We're not there to really answer that. But we'll write a competitive estimate, a comparative estimate that they can utilize to go back and begin negotiate. Now, even with that being said, when we write something comparative, which they're working off of Xactimates and mostly all of Xactimate, we work off of Xactimate and Stability, estimates are going to be pretty similar. Where they differ, even in these instances, are where they take something which is just sort of tools of the trade, and they charge for them. As far as mitigation is concerned, we have, thermal imaging. Used to be, the space age stuff. Now everybody has it. So it's similar to, if you're charging for thermal imaging, it would be similar to a carpenter charging you for use of his circular saw, in my opinion. Not really something that should be done. The other things that we see as far as, again, going back to the overscoping, is just normal residential losses, charging for supervision. Again, these are things that 99 times out of 100, we're not charging for. There are instances where you should charge for supervision, where you have large loss, 24 condo units that have been affected all the way, from top to bottom, or catastrophes that come through where you do need your supervisor on site 100% of the time. I agree with that. You should charge for it at that point. But it's being taken and just being sort of used just thrown in as a copy paste thing. Other issues are equipment. There are standards, again, that I talked about, the IRCRCS 500 and S520, that they kind of show us what we need to do in order to properly dry out a project. They don't necessarily give you that protocol, but they let you know, if you cannot dry this project out within 72 hours or better, then you should probably think about removing that product if it's a porous material, getting rid of it, because at that point, that's when mold can start to occur. But what some companies are going in and they're throwing in as much equipment as the circuitry will hold. And then at that point, leaving it in for an extended period of time. Dry, wet, doesn't matter. There are instances where you do need additional equipment when you're trying to dry hard to dry items, but again, it's not the case in a lot of these. They're leaving them in for an extended period of time, and they're charging for it. I've seen buildings that come through that they'll charge the dehumidifiers for 8 days, 5 days, 6 days. We as a company, again, there's a lot of companies that do this, but we as a company charge for a cap of 4 days on everything. In that, we even need some guidance from the adjusters, because again, if you're doing your job as per the standards, you should have that dried out within 72 hours. And you should be charging for those 72 hours. If we have something hard to dry, we ask for it, and we get the 4 days, but that's our limit, that's the cap. If we have to leave it in for any longer than that, it's on us. So that's...
Thank you. What is managed care program, and how can this help the agents when preferring a contractor?
Managed care is something it's widely used now. It really truly is. We're on many programs. We're not on all of the programs, but it gives, I guess, and again, I don't know the policy that well, but from what I understand, because of these issues with the AOBs and the overscoping, carriers, they trust our service. They know that we're reputable. They know that we're not going to overscope. They know that we're going to communicate properly too. We're not going to just go in, full speed and start start tearing things out that we think need to be taken out. Again, it's something that as agents, and again, and I'm sure you do, but you should really know that the carriers' vendor programs and who's preferred, and start utilizing it, because you know, it can only bode well for you all when it comes to your relationship with that carrier, I would think. Again, I'm not on that side of the fence, but that's it.
I have just one footnote to that. I mentioned this the other day. There's a lot of contractors here that use AOB, so just be careful. Even if you know that contractor that could be big in the area, look at the clerk of circuit courts for Manatee County, Sarasota County, Charlotte County. Look at their DBAs and their names and check to see how many carriers they have lawsuits against. And that should give you a good idea that they use AOBs. Yeah. So because they can tell you up front, we don't use AOBs. But come claim time, yeah, they will. So, that's it.
Okay. Yes.
I don't know if you went to any of the hearings. I went to a couple of them, watched a lot of them on TV. I used to be the legislative director for the Department of Professional Regulation, and there was actually 2 amendments that never made it to the hearing about having a separate classification for restoration companies licensed as a separate, standalone, specific classification within the construction licensing board. Are you guys ready for that? Do you think that would be a good thing?
Yes, I think it would be a great thing. Recently, back in, I think it was June of 17, is when the Department of Professional Regulations did take the mold-related industry and put that into effect. So because, you know, they were having problems with mold contractors, mold remediation contractors just taking advantage of the situation also. So now they have certain standards. You know, you have your CEUs that you have to have every 2 to 4 years. And to answer your question, I think it would be the same for water damage restoration. Should be the same, because it's just as important, if not more important, at this point, because you can salvage so much more if the proper steps are taken.
Any other questions? No? We do have dessert on the table if you'd like to help yourself while we draw the rest of the door prizes. Thank you very much. Oh my gosh, that is a lot table. Got one left, I'm just saying. Yeah. And you go.
Oh, for the
468-179.
That's me.
I got some. 468-171. All right, last but not least. 468-153. I think that's the last one, but last but not least, again, we have a lot of brochures. Our assignment of benefits brochure, alarms, and Damex some giveaways, we've got pens. Please visit our table before you leave. That's why we have this information. And
Thank you, everybody, for coming.